Hey, I'm Paul Rabalais, and in this video, I'm going to address which has priority, the will or the revocable living trust. Okay, so this video is in response to a comment I saw to one of my other videos in the last day or two, where I'm going to call him or her EG, because that's the initials that were in there in the comment. So EG said, I hope to understand this right. What has priority, the will or the revocable living trust? Thank you for the wealth of information. All right, well, thank you, EG, for watching and perhaps even becoming a subscriber, and then, of course, posting the comment, asking the question. All right, so this comes up a lot. People ask, Paul, I'm starting to learn about this, living trust, will stuff, but if the will says my stuff goes this way, and if my trust says my stuff goes that way, which one controls? Great question, and so I want to take it kind of slow, and I think I've got a little logical progression that's really going to give you a full understanding of how all of that works. Now, before I do that, let me just remind you, real important that you punch the subscribe. Don't punch it, just smash it. The subscribe button, that little red rectangular button, along with the notification bell. That way you don't miss anything in the future. And then just tune in every 10 a.m. Central Time every morning. More education, more estate planning educational videos. As long as I keep those subscribers and those likes coming in and those really constructive comments, that inspires me to keep educating people more. Okay, so let's start with this. So the trust, if someone sets up a living trust, and they probably did it in an attempt to title assets in their trust that would avoid having to go through the court and attorney involved probate process when they die, because things in a trust don't go through that. The trust controls the disposition of assets that are titled in the name of the trust when the trust maker, settlor, grantor, person who set up the trust, when that person dies. So let me give an example. Let's say an individual sets up a living trust and they retitle their investment account. John Smith has a living trust. And when he set up his living trust, he retitled his investment account at Schwab or Fidelity or Edward Jones or Merrill Lynch or in any of those places. He retitled that account from John Smith to John Smith as the trustee of the John Smith Revocable Living Trust, something like that. So when he dies, the provisions of his trust control the disposition of that asset. So if his trust says, when I die, I leave my my trust estate to my 3 children equally, or it may say I name my 3 children as the equal principal beneficiaries of my trust when I die, then that account is going to go to those 3 people that were listed as the principal beneficiaries of his trust to receive those trust assets when he dies. And his successor trustee will be able to go to that financial institution and just disperse those assets to the 3 children without needing all the court and attorney involvement. Excuse me. So that's that's kind of what the trust controls the disposition of. Now, next step. The will, the last will and testament, controls the disposition of assets that are titled in an individual's name when someone dies, or assets that are not have not been transferred into the trust during that trust maker or grantor or settlor's lifetime. So if that same individual also had an account, another account, investment account, in his or her name at that financial institution, then that individual's will would control the disposition of that account. And if the will said, I leave my estate to Fred, then Fred's going to get that account. Or if the person didn't even have a will, then the intestate laws or the state laws that govern who gets your stuff when you die would govern that account that was in John Smith's individual name when he died. Now that starts to sound really confusing, and I can see where that would appear to sound confusing, but let me clear things up a little bit, because when just about everybody, or when most people clearly establish a revocable living trust, they also create what they call a pour-over will. And the idea there is, yes, there's going to be things that are going to be in the person's trust when they die, and there may or may not be things that are in the person's name, individual name, when they die. And what the pour-over will does, it says, and I'm going to link you to a video where I better describe what a pour-over will is in that video that I'm linking you to. But the idea is when a person has a trust, they have a pour-over will, and their will says, I leave the assets that are subject to this will, if I have any, I leave my estate to my living trust. So under that previous scenario where John Smith had 2 investment accounts, one titled in the name of his trust and one titled in his name, and if he had a pour-over will, then that pour-over will, the survivors would have gone through the probate process to get that individual account poured over into his trust so that the trust beneficiaries would receive all of those assets. So that pour-over will is a kind of a key part of making sure that everything goes to the beneficiaries that are listed in that living trust. All right, now just a couple of side notes, important, but kind of on the side. You probably weren't even thinking of this when you asked the question, e.g., but I'll just throw it out there as a trust will kind of scenario. Sometimes people are a beneficiary of an irrevocable trust. So maybe a parent set up an irrevocable trust, the parent has passed away, and now the child is the beneficiary of a trust that exists. Now, in some cases, that child, through his or her will perhaps, can designate where their interest as a principal beneficiary goes when they die. Now, that all depends on the terms of the trust and what's permitted under trust law and all of that. But I just wanted to make the point that sometimes people are beneficiaries of a trust and they can direct where their interest in the trust goes when they die. And then going back to what we said earlier, so if you have a revocable living trust or are considering creating a revocable living trust, and if you did it or if you're considering it, one of the reasons you likely did it or you're considering doing it is that you want to arrange your estate so that there's none of that court and attorney, or at least it's significantly minimized, the court and attorney involvement in the settling of your estate when you die, because things in a trust don't have to go through that court and attorney involvement. So if you have a living trust, it does behoove you to retitle assets that are in your name into your trust. So typically when somebody sets up a trust, the lawyer prepares all the paperwork to retitle all of your real estate into the trust and gets all that recorded in the appropriate places in the land records. And then there's also typically a process of perhaps retitling financial accounts. Some financial accounts, if you're trying to avoid probate, don't need to be retitled because certain accounts like IRAs, life insurance, annuities, they have beneficiaries. Those avoid probate by their nature. And then, so I'm gonna link you to another video that talks about if you do have a revocable living trust, how important that funding or that retitling of assets is. And then I'm also going to link you to one other video that talks about if you have a living trust and there's still assets in your name when you pass away, how that probate may be easier than if you had no living trust at all. So linking you up there to the third video that I've linked you to during this video. Okay, well, I hope you got some time to watch all those videos, but I think they'll be informational and helpful. In fact, feel free in the comments below to, constructive comments are phenomenal, especially the ones that may even be proofread and given some thought, and so that's all awesome. All right, so just again, hit the subscribe button, tune in 10 a.m. Central Time every morning. Look forward to giving you more education to the extent I can and to the extent I don't run out of it. So y'all have a great day. We'll see you tomorrow.